Hello, I hope you are doing well. My name is Jacqueline Vino from Galasso Learning Solutions, and welcome to the Genuine Learning blog. Today we are going to cover a very important topic, which is the cornerstone of the accounting profession. You guessed it, we're going to talk about ethics. More specifically, the AICPA's Professional Ethics Executive Committee, or PEEC for short, has recently proposed a revised interpretation in the area of simultaneous employment, which is very exciting. It's a project that they've been working on for quite some time now, so it's wonderful that we've seen some movement in this area. So what we are going to do during the blog today is discuss some of the background information and history of simultaneous employment. How did we actually get to this point that we're at today? And also, what are some key updates once this is finally approved and effective? So we have a lot of information to get through during this blog today. So with that being said, let's go ahead and get started. So as you can see here, this proposed revision was issued by PEEC in December 16th of 2024. So really not too long ago, a fairly recent item here. And just to give you a little bit of history on this, the current interpretation that we have that this will eventually replace basically prohibits all partners and all professional employees at a firm from being employed or associated with the attest client. However, there are two little exceptions that are in the guidance as well. So the first exception to the rule is if you are an adjunct faculty member at an educational institution. So think of a partner at a CPA firm that is also an adjunct accounting professor at their local college or university. And then we have another exception for members of government audit organizations. So right now what we have is currently just that line in the sand saying that you are not able to be employed or associated with the attest client unless you fall into those two exceptions. So that's the current guidance that we're working with here. So what happened though is in PEEC's 2021 to 2023 strategy and work plan, they were basically trying to figure out, should there be any additional exceptions to this outside of just the adjunct faculty members and members of government audit organizations? And what kept coming up was, what if we have a partner or an employee at a firm that is simultaneously employed with the U.S. Armed Forces while that firm is also performing an audit of a branch of the military? So let's say we have somebody who is potentially in the National Guard and they get called to service, and maybe their firm is also working on test work for that branch of the military. They were saying, would that create a simultaneous employment issue or would that not create a simultaneous employment issue? And what we have as a result of that is the USERRA temporary enforcement that came out of that discussion. So since that is a temporary enforcement, we are basically going to have that until this more formalized proposed revision is eventually effective and adopted by everybody. So basically, PEEC did a lot of work on this. They basically distributed a survey to more than 500 stakeholders. Of those 500 stakeholders, 77 people responded, and we're all pretty much in favor of PEEC going ahead and revising the old interpretation to have something a little bit more modern, because this area has not been changed in over 20 years. So very exciting that we have some movement in this area here. So first and foremost, one of the primary updates from this proposed revised interpretation is a new definition. Very exciting. However, before we take a look at this new definition, let's take a moment and reflect on what the old definition said. So in the extant interpretation, the definition of simultaneous employment was very, very specific, where they actually listed out roles that you could not have. So they listed out, director, officer, employee, a promoter, an underwriter, a voting trustee. So very, very specific in the old definition. So what PEEC is proposing in this new definition is to remove all of that language that was currently in there. So what does this new definition say? Simultaneously employed or associated actually is going to mean that when a partner or professional employee of the member's firm serves in a governance role, so governance role, we're going to put a pin in that and come back to it. That's very, very important. Or as an employee of an attest client during the period of professional engagement. This includes also contractors or volunteer positions as well. So as you can see here, the definition is a lot more broad in a lot of ways, right? We're not including specific titles like director or officer or, promoter. We're actually just talking about, who is actually charged with governance here. So if we are meeting the definition of being charged with governance, we're able to oversee the strategic direction of the organization. That is going to fall under this definition here, which I think is really interesting. So moving away from those specific titles, more focusing on, okay, what can you actually do at the attest client? And here is an update to the actual guidance that reflects this change. So as you can see here, they crossed out the lines that say the official title, like official or officers, directors, and instead they replaced that with a key position. So if you are in a key position and you are charged with governance, you're able to impact the organization and their strategic direction. So if you are in a key position at the attest client, it is going to create a management participation threat. And another thing that's really interesting about this proposed revised interpretation is that they are proposing two sides of the house here. First, we have the rules-based approach, and they're also trying to propose a more principles-based approach as well. So this revised interpretation is kind of a hybrid between the two here. So first, let's take a look at the rules-based approach, right? We still have those lines in the sand that we have to contend with. So first and foremost, the proposed interpretation is going to prohibit covered members from any simultaneous employment or association with the attest client, right? As you can see, very much rules-based here. In addition, no partner or professional employee at the firm can hold a key position at the attest client. So again, thinking about that revised definition that we just went over together for simultaneous employment, very much pointing out what is that key position. But as I mentioned, we also have a more principles-based approach as well. So what are we going to do if we find ourselves in this situation at our firm? So under this proposed revised interpretation, there are some steps that we're going to have to take. So first and foremost, we have to report the offer to the right person at our firm if we find ourselves in this sort of scenario. And secondly, we need to apply the conceptual framework to try to evaluate whether threats are going to be at an acceptable level or not. So if they are not at an acceptable level, then we're going to have to go in and apply some safeguards to either eliminate the threat or reduce it to an acceptable level. So this is how the more principles-based side of the house is coming into this revised interpretation. Another thing that I really like is there are various factors that we have to consider when we're trying to apply this conceptual framework. We have to think about things like, what is the actual position that we have at our firm? Are we a partner at the firm? Are we staff? Maybe we're a manager. We want to think about exactly what our role is at the firm. And also, what is our role at the attest client? Are we somebody that's charged with governance? Are we holding a key position? Or are we just an employee of that client? So just trying to think about all of these things here. What is the level of assurance of the attest engagement? Is it reasonable assurance like an audit? Do we have limited assurance? Maybe we're doing some review procedures. We want to consider that as well. What is the size and structure of the attest client? So we want to have all of these considerations and factors that are going to come into play when we are applying the conceptual framework. So what do we need to do if there are some threats? Of course, we're going to have to apply some safeguards. And what do safeguards do? They either eliminate the threat or they reduce the threat to a more acceptable level. So sometimes we just need to apply one safeguard. Sometimes we have to apply many safeguards. And maybe if we are applying safeguards and we're still not able to reduce that threat to a more acceptable level, then in that case, independence is going to be impaired. So what are some examples of safeguards that we could apply to potentially reduce this threat? Maybe we have a reviewer who has not provided services to the attest client to be the one who is reviewing the attest work that is being performed, right? That would be an example here of a safeguard that could be applied. Now, another thing that's really interesting is what if there is an independent contractor that is involved in this whole mix here? So PEEC also has a whole separate section within the guidance on independent contractors and what to do in this proposed revised interpretation. It basically says that when an employee of an attest client is engaged as an independent contractor by the firm to provide professional services to the attest client, threats are not going to be on an acceptable level for us and independence is going to be impaired if any one of these little circumstances here that you see on your screen are met. So for example, the member of the attest engagement team is for that same attest client. So if they're on the actual attest engagement team and they're an independent contractor, right, that's going to be a breach to independence there. Maybe they're in a position to influence the attest engagement team. They're in a key position at the attest client, so maybe they're charged with governance, for instance, and they are associated with the same attest client in a role held by those charged with governance. So once again, have a whole separate section there on independent contractors, which I find to be very interesting. And in addition to that, we also have 3 exceptions to this proposed revised interpretation. So remember, in the old guidance, what we have, the current guidance that we are working off of, we have those 2 exceptions, right? We have the first one here, which is adjunct faculty at colleges and universities. So the same exception that we used to have, we still have in this revised interpretation. So what this is basically saying is that you can be a partner at a firm And that same firm can provide attest work to the institution so long as you are applying these safeguards here. And of course, all of these safeguards have to be met. So the partner that is the adjunct faculty member is not in a key position at the educational institution, right? So in this case, they're just a professor, an adjunct professor. They're just teaching a class or two, not in a key position at the college or university. They're also not working on that particular attest engagement team. So they're not working on that audit, for example. Somebody else is going to be working on that, and they cannot influence the attest engagement. So again, another exception that we have laid out in this guidance. And we also still have the exception that was in place for government audit organizations. So basically the member can perform an attest engagement for a government entity so long as the head of the government audit organization has sufficient oversight and meets at least one of the criteria that you see on your screen here. The first one, right, elected directly by voters, or they are appointed potentially by a legislative body, and that body has the power to remove them as well. And last but certainly not least, they are appointed by somebody else, so long as the legislative body confirms the appointment and has oversight over that removal. So we still have those same two exceptions that we used to have. But one thing that is a change from the old guidance is that we have this new third exception that wasn't there before. So basically, this is where the USERRA is coming into play, where we have members of the armed forces. So if a partner or employee works for an attest client, what they're stating here is that independence is not going to be impaired when compliance with employment laws conflict with the interpretation. So that's exactly what USERRA was. You can't punish somebody that works for you for being a member of the armed forces. So basically, as long as we go ahead and apply these safeguards, it is going to be totally acceptable for us. So as long as that person that is in the military does not hold a key position or governance role at the client, they are not part of that specific attest engagement team, and they cannot influence the attest engagement. So really this third exception here is one of the primary changes that we have from the current guidance. And I'm a visual person just naturally, so this visually lays it out for us here. So as you can see, we have the rules-based approach baked into this, and then we also have the more principles-based approach, right? So if you're a covered member, you are not able to serve in a governance role or as an employee. If you're a partner or professional employee, right now you're no longer allowed to have that key position, as opposed to listing out you cannot be an officer or you cannot be a director, right? So we're narrowing that down to just a key position, somebody that can influence that attest client. Now, if you're an independent contractor of the firm providing professional services to an attest client, where that individual is also employed, right? You cannot work as a governance or key position at the attest client and firm. You cannot be on the engagement team, and you cannot influence the engagement in any way. Any other sort of relationship, we're going to apply that conceptual framework, like I mentioned, considering all of those different factors, right? What is your role at the firm? What is your role at the attest client? And then, of course, we have those three exceptions that we just talked about. So the adjunct faculty, the government audit organization, and then USERRA. So that means confirming with any employment laws. And we just have a link to access that visual as well. So when are comments due on this proposed revised interpretation? You have until March 16th of this year to get back and provide any feedback. But that does summarize what we have for today. As you can see, lots of different interesting factors. I did mention that this one is really a long time coming, so it is really exciting to see that PEEC has officially issued their revised interpretation. So very excited to see what the final product is going to look like. But once again, my name is Jacqueline Vino, and thank you for tuning in to the Genuine Learning blog. I hope to see you on a later blog. Thank you and have a great day.